I'm going to go ahead and welcome everybody to the Morning Fuel show. We've got quite a few participants already loaded up for this for NFP today. This is a little bit of a continuation of discussion about employees and employers, things to consider from a standpoint of insurance and those programs that are out there, and we're trying to kind of demystify a little bit for our membership, of which NFP is a member of our organization, and they also a little bit later, Jordan Cook will tell you a little bit about what they're doing with directly to provide benefits for our membership. That said, welcome to the show, Cooper Johnson, who's going to kick off and talk a little bit about, to give you a little rundown on NFP. Later, he'll introduce Beth Allen to go through a quick slideshow similar to what we did last week. And then I think Jordan's going to clean up and talk a little bit about the specific deal that NFP's worked on with the Alliance. So with that said, Cooper, kick it off.
David, thanks. Proud to be part of the Morning Fuel program. Have enjoyed these last few weeks, and I know you like to run a tight ship, so I'm going to keep my talking to a minimum so we can stay on time. A little bit about NFP. We're a proud partner of the Petroleum Alliance of Oklahoma. We are an international insurance brokerage and consulting firm with about 6,000 employees throughout the United States, Canada, and Great Britain and the Caribbean. We specialize in everything from corporate benefits to commercial property and casualty, retirement, executive benefits, individual solutions, including personal P&C, wealth management, life insurance, and so on. Our main, obviously, asset is our employees. One of my favorite employees out of our 6,000 at NFP is Beth Allen. So we're super excited to have her on today. Beth is a senior VP of our compliance department. She comes out and does lots of client-facing meetings throughout the year, and we're lucky every time we have her. She has a wealth of knowledge. Beth is a former attorney with the Department of Labor. So not only is she very familiar with the corporate benefit side, but she knows what the other side is looking for. So without further ado, I'd like to go ahead and introduce Beth to kind of go through our program today. And again, Beth, thank you so much for taking the time to join us on Morning Fuel here in Oklahoma.
Sure. Thank you so much, Cooper. And thank you everyone at the Petroleum Alliance for inviting me to do this call. As Cooper mentioned, I work with NFP's benefits compliance team. And so essentially we work with our clients all across the country to make sure that their plans are compliant. And so I understand that last week y'all had a pretty good presentation concerning kind of some of the employment law aspects of what's going on with the COVID-19 crisis. And today I'm really going to focus on just the benefits compliance issues that we see coming up, okay? And so there's kind of a lot of information that's going to be coming today. Keep in mind that, I'm going to try and stay honest on the time here, but we also invite you to ask questions that you might have, and I'm going to keep a nice look at the chat box for questions that might come up, okay? So with that, I'm going to go ahead and jump us into the content of today's call. Before kind of going further, I always have to give kind of those lawyer disclaimers that, this presentation is just for informational purposes, and I'm not your lawyer or your accountant, so this is not tax or legal advice, but I think it'll still be a good conversation. So just kind of going into what I wanted to present on today, I thought I would kind of bring up what we have been advising employers on all across the country from the standpoint of just kind of the top 5 issues that we see coming up as it pertains to benefits and compliance. And so that's what I'm going to focus on today. That first piece with the FFCRA, or the Families First Coronavirus Response Act, last week's call actually went into that quite a bit, but I'm going to do a brief review and then try and give you some examples for those of you who actually have to comply with with the FFCRA. Then we're going to go into a discussion of the CARES Act. We've been getting a lot of questions about furloughs and kind of what that means for purposes of benefits, so I'm going to discuss that. In addition to kind of some of the insurance changes that we're seeing come either from state insurance department requirements or from just the insurers making certain decisions about how the coverage might change. And then finally, just a couple of odds and ends as far as compliance is concerned with this whole crisis. And so jumping into the FFCRA, again, this was discussed at length on last week's call, but basically this was one of the probably first or second pieces of legislation that we got from the government. And it basically provided this requirement for employers that are under 500 employees to provide expanded FMLA or emergency paid sick leave to people who have to take leave because of COVID-19 related reasons, okay? Along with this particular requirement to offer those type of leaves, it also provides a tax credit to employers who are gonna provide that leave to their employees. And then also kind of one minor piece we saw is that it also mandated COVID-19 testing without cost sharing. So obviously the government is really interested in as many people getting tested as possible. And so they want there not to be any barriers to testing. So I think that one of the good things about kind of how to explain this is maybe to give a flow chart, right? Like I'm a visual learner. And so like, I think it's good to realize that when it comes to both expanded FMLA and emergency paid sick leave, there's a flow that you have to consider when you determine if it's going to be, applicable to a certain employee who might want to take that leave. And so expanded FMLA, we basically start with the question of whether or not the employer has less than 500 employees. If they do, then they're probably going to have to comply with the FFCRA requirement on expanded FMLA. Then the question becomes, has the employee worked at least 30 days for the employer? And if they have, then they could also take this leave. Then the question becomes, does the employee need to miss work to care for their son or daughter whose school or place of care was closed because of COVID-19? And I worded that kind of need to miss work, and I know it doesn't sound as professional, but I think it goes to the point here because the issue becomes that if the person can actually work, whether that be on-site or telework, then they may not need to take this leave. However, if they do actually need to take leave to take care of their child, but they can still work, then that would be a situation where EFMLA would apply. And so if they do actually need to miss the work that they can work, then the employee could take up to 12 weeks of job protected FMLA leave. And there's kind of some distinction about, whether or not that leave is unpaid or paid that I've provided there. And I see we did get a question about the slides being provided, and I'm sure that that's something that the Alliance will provide. So moving to emergency paid sick leave, it's slightly different because it's still the same question of whether or not there's less than 500 employees, but then it really goes into whether or not the employee needs to miss work for one of the 6 recognized reasons. And so those reasons are listed here, and they really have to do with whether or not the person was quarantined or isolated by a federal, state, or local order, and that does include the shelter-in-place orders that are being put out by various states and localities. If they've been advised by a healthcare professional to stay home, it's the same. If they're experiencing symptoms and seeking medical diagnosis, that's another reason. Or if they're caring for an individual who is basically quarantined because of COVID-19 reasons. And then emergency paid sick leave actually also includes a situation where the employee has to take care of their child. And so how that generally is going to look is that they would be able to have up to 80 hours of leave under the emergency paid sick leave. And a lot of employees might opt to take, those 80 hours to receive pay for the first 10 days of the emergency FMLA that wasn't paid. Okay, so that's kind of one thing to keep in mind. And again, the numbers are here. In the interest of time, I'm not going into a whole lot of details.
Okay. And so the small employer exemption, basically, we've been getting a lot of questions about the fact that the FFCRA says that if you have less than 50 employees, then you could potentially say that you're not going to offer leave for the employee to take care of their child. And I think that's one thing to point out is that it doesn't exempt you from all of the reasons someone might have to take COVID-19 leave. If they actually have COVID-19 or are being diagnosed with it, then they still get to take leave under the emergency paid sick leave. But the exemption is available if they want to take that leave to take care of a child. However, they have to be able to say that that person taking leave would cause their business to not be viable. Okay, and so the idea would not just be that this person, they don't want this person to take leave. It has to be that if they took the leave, that would actually jeopardize the viability of the employer's business. And so that's kind of just one thing to keep in mind. So, and another thing that I'll point out is that, you know, an individual would be eligible for FFCRA leave if they could work, but for an approved COVID-19 reason. And so the idea would be that if they could not work, let's say they were furloughed, then FFCRA leave wouldn't be available to them because they couldn't work whether they had the COVID-19 reason or not. If the business shut down, then they couldn't work and they wouldn't be due this leave. And so you want to keep in mind that this is really just a situation where employees can still work, but cannot work because of the fact that they're dealing with the COVID-19 reason. Also keep in mind that FFCRA leave doesn't actually impact or decrease somebody's right to certain benefits under, let's say, their employer's PTO policy or a state required leave. And so you couldn't necessarily say as an employer that I'm just going to pay you out your PTO instead of offering you the leave that's required under the FFCRA, because theoretically they would be entitled to both the leave under the FFCRA and their PTO as well. And so there's some questions and answers from the DOL that get into kind of how your PTO would integrate with FFCRA leave, but keep in mind that you're not going to be able to kind of take away the employee's rights to any of those additional benefits that they normally have. And then also, you know, for those of you who may be at a company that's over 500 or 500 or more, you still have issues of conventional FMLA. So that's the FMLA that was in place before FFCRA came out. And the idea there would be that if somebody is actually ill with COVID-19, then that's a serious illness and they'd have to be given that's up to 12 weeks of unpaid leave. So keep that in mind, even if your company is over 500. And then finally, the tax credits that are provided are only for, you know, the wages paid and the benefits provided under FFCRA. And so that's something that you would want to work with your accountant to claim, but it is an opportunity. And so I thought I would do some scenarios really quickly, just because I think that practical application is usually a lot, you know, better. And so, for example, we have Maria here, who works as a crane operator for an oil and gas company. And forgive me if I don't know these terms. You know, I thought I would try and be kitschy and, you know, maybe make things applicable to you all. But, you know, this is what she does. She works as a crane operator and they're open for business. However, Maria has a 3-year-old child whose daycare is closed. So she can't work from home because she's a crane operator, right? But she also needs to take care of her child. She's going to be eligible for both the expanded FMLA and emergency paid sick leave to take care of her child. And so what that could mean is that she's going to use the emergency paid sick leave for the 10 days before payment under expanded FMLA kicks in, okay? And then I've also included some information about what Maria should do to basically request that leave from her employer. To go into another example, Tommy works as a non-essential employee of an oil and gas company. I brought that up because we get a lot of questions about businesses that might have been deemed essential or not, and kind of what it means for their employees who do have to come to work versus those who cannot come to work. And so this is a situation because he's actually not allowed to come into work, again, because his job is not essential, because of the state local order, and he can't work from home. And so basically they don't have any work for him. So even though he has an 8-year-old child whose school was closed and he needs to care for him, he's actually not eligible for expanded FMLA or emergency paid sick leave because he's basically been deemed not essential and there's no work for him to do, right? And so in this type of situation, Tommy would basically seek unemployment. But really, you know, this scenario is just to underscore the idea that if there's not work for the person, then you're not providing them leave under FFCRA. And the answer would kind of be the same if Tommy, for example, was furloughed. Another example is that Esther is a customer service analyst for an energy company, and that company is having their employees work from home during the crisis, okay? So she could potentially work from home, but she is actually experiencing COVID-19 symptoms and seeking medical diagnosis. Because of the fact that she's actually experiencing symptoms and seeking diagnosis, she would be eligible for up to 80 hours of emergency paid sick leave, okay? And we want to point this out because, you know, employers might think, well, she can telework, so why can't I actually make her work even though she's sick? And the idea is that if I'm sick and actually dealing with this illness, I should be able to kind of take that time off under the FFCRA. And so again, here's some information about the you know, what the employer could request Esther to provide to provide that leave. And then one final scenario is that Ruben works as a drilling engineer for a small oil and gas company that has less than 50 employees. And he's been diagnosed with and is ill from COVID-19, okay? In this situation, Ruben is going to be eligible for emergency paid sick leave, because even if the employer wants to claim the small employer exemption, that does not apply if someone is actually sick from COVID-19, right? It would only apply if he had wanted to take the time to care for a child. And so again, Ruben should request, or provide the information to the employer, to prove that he needs that leave, basically. And so with that said, that's kind of just a brief review of the FFCRA that I thought I would go through. And if you have any questions, again, feel free to enter them into the chat, or just make yourself, or I'm also going to provide some resources at the end, that if you want to read some more into this information, you can. And so moving on to the CARES Act, and it's hard at this point to kind of keep track of all the different phases that the government has gone through about their legislation that they're providing. But the CARES Act came out after the FFCRA, and this is kind of, I think, what most of your employees are going to know the most about, because this was the piece of legislation that allowed for the $1,200 or $2,400 stimulus amounts that were paid to individuals. Also, as a part of the CARES Act, we saw some loans to small businesses that a lot of businesses are trying to avail themselves of. There was an unemployment benefit expansion, but then there were also a number of employee benefit related provisions, and that's what I'm going to focus on for the next few minutes. So first, as it pertains to health plans, we saw that the CARES Act basically came out and said that all telehealth coverage could be offered without cost sharing, and that's going to be even for your high deductible health plans that might offer an HSA. And that's important because generally, if you have any coverage that can be paid before the statutory deductible, then that's going to make someone ineligible for an HSA. So the government kind of came out very quickly and said, hey, we realize now more than ever, we don't want everybody going to the doctor. We want people taking advantage of telehealth. And so if your plan allows for telehealth without cost sharing, then you will not jeopardize your employees' HSA eligibility. So that was welcome guidance. This is also where we saw some guidance about the fact that now over-the-counter drugs and menstrual products can be reimbursed out of HSAs, HRAs, and FSAs. Before the CARES Act, the ACA actually specifically said that you couldn't use those accounts to pay for over-the-counter drugs. They have now changed this, and importantly, this is actually one of the elements of the CARES Act that they gave a retroactive effective date. So basically, your employees could go back as of January 1, 2020, and reimburse any of the over-the-counter drugs that they bought. The CARES Act also expanded the types of COVID-19 tests that are available and must be covered without cost sharing, and required for COVID-19 test providers to publicize the cash price so that people would kind of know what their cost is on that. Retirement plan provisions, I know that we talk a lot about health, but I just will also bring up that for those of you who sponsor retirement plans, the CARES Act did actually provide some increased access to hardship distributions and loans. That's really going to be for qualified individuals who are people who are basically affected by COVID-19, right? So it can't just be that any of your employees can take advantage of this. It really does have to be those people who might have, let's say, had a spouse who lost a job or are dealing with any kind of financial uncertainty because of the crisis. And so there's a little bit of wiggle room there where they could take larger hardship distributions and larger loans than they could before. They also waived the required minimum distribution. So if you have any employees that are over 72 years of age, they don't actually have to take those required minimum distributions for the rest of 2020. And they also kind of came out in this rule and said that the DOL could delay different ERISA deadlines. Now, interestingly enough, this stuff is changing so rapidly that just this morning, we did get guidance from the DOL that they are going to be pushing back a lot of the due dates that are going to come up in the next few months. And so I think most notably is the Form 5500 filing requirement for employers that would have to file in July would probably have that extended. But that's guidance they just put out this morning, so it's very fresh. And so that's kind of just an understanding of the CARES Act. I'm going to move on to, and I know I'm moving really fast, and so please, again, stop me if you have any questions. But, the impact of furlough and layoffs is what I think, our team got the most questions about very early on, because a lot of employers were looking at kind of just having to send people home if they're not, having people, obviously patron their business during this time. And so kind of the number one question that we got was basically, if we lay people off or if we furlough them, what happens to their benefits and what can we do? And basically that's going to depend on, the terms of the plan. So often your plan will say that employees are eligible if they work 30 hours a week, or if they, as long as they're actively at work and don't go out on leave for more than 30 or 60 days, then they're going to remain eligible. And so first, employers are going to need to look at the terms of their plan to determine whether those people on furlough or who are being laid off would actually still be able to be covered under the plan. Those of you who are subject to the employer mandate because you're 50 or more would have to consider whether or not, there's a requirement to continue offering coverage based on the look back measurement or the measurement period. Now that's a harder discussion. I'm not even going to go into that because it could take all day. But just keep in mind that if you are over 50, then you want to be talking to kind of your service providers about kind of what that can mean under the employer mandate. And then finally, the Section 125 or qualifying event rules, if you provide that coverage on a pre-tax basis, also will determine like whether or not employees could even change their coverage, could stop their coverage based on whether or not they lose eligibility. And so those are some issues that you want to consider when you're thinking about the continued eligibility for benefits. As far as participant payment during furloughs, we're getting a lot of questions about that. And kind of what we just say is generally, the IRS and the DOL allow during an FMLA leave for you to have the person pay upfront, but they have to agree, and most of the time they don't. You can have them pay during the leave, or you can have them pay upon their return. So if you already have a policy in place that says how you deal with that, then that's best. But if you don't have a policy, then you do want to make sure that you communicate to employees how you expect them to pay for their coverage while they're on furlough, especially if they're not receiving any kind of payment from you, okay? Also keep in mind that an offer of COBRA would be due if the coverage is actually terminated. And so, for example, this might not be in the furlough situation if you don't actually terminate their coverage, but if you lay them off or terminate them, then they're probably going to be doing offer of COBRA just like they would if you terminated them at a regular time. One final point that I'll make is that coverage reinstatement after they return from the furlough is really going to go back to the same issues of eligibility that we talked about. And so, for example, when they return, whether or not they have to go through a waiting period again, or whether or not they can be put immediately into coverage, generally it's going to go back to the Section 125 qualifying event rules that basically say if you're gone for less than 30 days, then you just come back and coverage continues like it would have before. If you're gone for more than 30 days, then you could potentially, have them change their election, or they could choose to change their election. If you're subject to the employer mandate, that's also a situation here because there's a rehire rule that says that if someone is gone for less than 13 weeks, you have to basically offer them the same coverage basically on the day they come back in order for it to be an appropriate offer under the employer mandate. And so just keep in mind that the idea of what should happen when they return back to work is also going to be based on the same rules that we discussed on eligibility. One final kind of slide I'll talk about just briefly is we're getting a lot of questions about the impact of furloughs and the reimbursement accounts. And so if someone has an FSA or a flexible spending account, or if they have a dependent care assistance plan, and what that means and whether or not the person can stop their contributions or has to keep going. And for the DCAP or the dependent care program, I think that's the easiest because it's pretty, they're pretty like, those rules are very lenient, right? The idea is that if you have a child who was having childcare and they don't need childcare anymore because their daycare is closed, then you could stop your DCAP contribution. And that makes sense because again, if your child is at home, they're not actually receiving the childcare that you're using the DCAP for. The only thing about that is that, whatever you have contributed to this point in the year probably has to stay there. Now we're hoping that later in the year, you'll be able to use those funds to pay for childcare. Let's say when we start sending children back to wherever they were getting care. But just keep in mind that you probably can stop or at least decrease your DCAP while you have your kids at home. The FSA or a flexible spending account election changes are also going to be tied to plan eligibility. And so, for example, if you remain eligible for the FSA, then potentially you would just continue in the FSA, and then it would be a question about whether or not you're going to, how you're going to pay your employer back when you return. But if you become ineligible for the FSA, then technically, you would stop your FSA contributions because you're technically no longer covered under the FSA. And then you kind of have a question of whether or not the account was underspent or overspent and what that means. Generally, if it's underspent, then you could select COBRA for your FSA if you are no longer eligible. If it's overspent, then what I've seen a lot of employers do is basically just say, we're going to have you repay us the FSA upon your return. And that's generally going to be the best route to take for the employer to kind of minimize their risk basically. And then finally, HSA changes or health savings account changes, those are always allowed and have to be allowed at least monthly. So anybody at any point, even if it wasn't COVID, could come to you and say, hey, I want to decrease my HSA contribution. And so you have to allow that. And then finally, one thing I'll notice, we've been getting a couple questions, and I'm trying to keep track of time here, but we've been getting a couple questions about employer contributions. And so the employer might want to decrease their contribution. And if they do that, then they just need to be mindful that they'll need to notify their employees. And it could cause kind of a qualifying event where employees might want to drop off your plan. So keep that in mind as well. So moving on to just potential insurance coverage changes. With this, the whole point of this is that we've seen some, state mandated insurance requirements. And so that might be where the state says that they're going to expand the use of telehealth, that they're going to ask or require their insurers not to, cancel anybody's coverage for non-payment. They might provide additional, drug refill opportunities. Oklahoma specifically kind of did more of a suggestion to insurers that they should be flexible with employers about, paying their premiums. They didn't necessarily require a grace period, but they did strongly suggest it. They also did come out with some changes on drug refills. And just keep in mind that if you have employers in different those state mandated insurance requirements may or may not apply depending on if your plan is fully insured or self-insured. We're also seeing where some insurers are providing premium discounts or holidays, and you want to make sure that if there's a premium discount provided, it can't all just go to the employer if employees are also paying premiums. And then finally, we're seeing where employers are, some insurers are offering special enrollment events or offering people the chance to, receive different benefits, and that's going to have implications under the qualifying event rules. And so just moving on to kind of the last portion of remaining compliant obligations, we're having a lot of discussions about HIPAA and privacy considerations. If you know that someone is diagnosed with COVID-19, you can't just go share that with all of your employees, right? And even if it's not something that is, subject to HIPAA, because let's say you didn't hear about it through kind of your health plan, let's say the employee just told you, Americans with Disabilities Act, or the ADA, is still going to say that if you get that kind of information from an employee, you can't just share it. So keep in mind that you're going to want to basically only provide that information to the least amount of people that are necessary to kind of achieve what you need to achieve. We're also seeing where some employers are going to need to make plan amendments. So some of those changes we talked about that are provided through the CARES Act may actually require for you to amend your plan. The good thing is that the DOL and the IRS have given us a little bit of leeway to kind of have some time to make those amendments, so you don't have to worry about those right now, but there will need to be plan amendments made to your plan at some point just to reflect that during this period of time, the terms of your plan were essentially different. One additional point I'll make is that with electronic disclosure, a lot of employers, you might not have an option if your employees are not coming into work to provide them with, paper documents or to mail it to them. And so just keep in mind that if you're going to use electronic disclosure, that you want to make sure that you are, following the rules on that. And then finally, state leave and employment law requirements could apply. And so just make sure that you're kind of keeping your ear to the streets on any HR requirements as far as state leave are concerned, because some of the states are coming out with requirements to provide certain leave to employees while we're dealing with COVID-19, and those would apply if you have employees in those states. And so I just see one question really quickly about are providers being fairly nimble to requested changes by clients? And generally, a lot of the insurers are pretty much being pretty flexible. I'll leave that maybe to Cooper to talk about, but I know that kind of everybody understands that we're going through it right now. And so in my experience, they are being fairly flexible. And so sorry, go ahead.
Yeah, I'd agree with that too, Beth. I'd say the providers or the carriers are probably being even more flexible than the letter of the law. And most of them have extended their grace periods from 30 days to 60 days in terms of paying the premium. Obviously, employers need to keep in mind, it's just a grace period. They're not saying you don't have to pay your bill. You got to pay your bill. They're just giving you more time to get it done.
Hey, Beth, I got a quick question for you.
Sure.
I've actually been asked this, and it was like one of the chat questions last week was, let's say somebody's tunnel working and they get and it's deemed by the employer that, hey, you can't do all of your job, like maybe half your job for more. And they kind of furlough half your salary or make some sort of adjustment, does that disqualify that employee? Because it was pretty, I know things are gray, but it was pretty black and white from last week that working at home is work.
Mm-hmm.
But if somehow they've adjusted your compensation, because does that create a opportunity for the employee to be reimbursed in some way?
So what I think you're saying is that, let's say they kind of force someone to go to part-time hours. Is that kind of what you're alleging? Yeah.
They can't complete all their tasks remote.
Right. So it's kind of interesting because remember I kind of talked about that but-for analysis, right? And whether or not there's actually work for you to do, right? Like, because the weird thing is, if what that means is that half of the time there is not work for you to do, then believe it or not, you're actually not going to be eligible for FFCRA for that half of the time. And it's going to be basically like your employer just basically sent you into underemployment, which might actually qualify you for unemployment, right? Like a lot of the states, it's not an all or nothing. If you're working less hours or substantially less hours than you were working before, you could be eligible for unemployment. And so that probably is going to be what would happen in that scenario, but not necessarily FFCRA leave.
Thank you.
So Coop, you want to kick it off and talk about the association health plan?
I actually have my Clorox wipe to back cleanup here. This is Jordan Cook with NFP. Thank you, Beth, for sharing your expertise and all of your time today. This was great. Very timely that the Alliance launched their Petroleum Alliance Health and Benefits Plan. I want to remind everyone that we are sending in quotes for our clients at NFP, and I've been really pleased with the recent launch of that. The program really does lessen the burden of benefits administration. And then also, kind of Beth brought up COBRA. It provides COBRA administration and COBRA benefits to all participants. So that's been a great benefit that we've noticed. So if you wanted more information, email benefits@okpetro.com. I'll have you go to the next slide. And again, Dave, thanks for having us on today.
Yeah, well, guys, this was really informative. I like we are going to make the presentation available there's a resource page at the back of Beth's presentation that has a lot of links that you can go to, which I think are helpful. I like the manner that lists and flowcharts were given. I too am pretty visual about things. We certainly appreciate you guys being on and helping through this time. I think most of it boils down to common sense and dealing with people the way you want to be dealt with. This is last couple of weeks we've been able to not only point employees the right direction, but point the employers the right direction. I understand that NFP is a 3-time consecutive year winner of being one of the best places on the planet if you're in business insurance to work. So I'm sure that that's following through with the advice you're giving us, and we certainly appreciate it, guys. So thanks for being on.
Thank you, Dave.
Right.
Real quickly, next week, very excited about this. We're going to have Brooke Simmons, our newly minted, not new to all of us, but newly minted Alliance president. Went through an exhaustive search to put the right person in the right job. We're very excited to have him, and he is going to talk about his vision for the Alliance and how we're going to accomplish the many hurdles that are in front of us. So thank you.